So today we're going to be learning more about pool trusts, and I think we what two of the ARC's affiliates, Berkshire County ARC and the ARC of Bristol County, um, provide pool trust services to individuals and families who are looking for a different method about being able to manage resources for their loved ones and that sort of thing. So I'm thrilled to have Marianne Hyatt from the Berkshire County ARC and Michael Andrade, who is from the ARC of Bristol County, be our speakers today. So I wanted to again welcome everyone. Looks like we have no problems with the audio or the visuals. So what I would also like you to do, just one more thing for the chat box, if you could just let us know, if you're a parent, if you could just say hi in the chat box. All right, lots of parents with us today, which is terrific. How about if you are a professional? Okay, so it looks like we have mostly parents, but some, and I think maybe a couple of you are both parents and professionals. So that's great. Very excited to have you all on today. So we have muted you all upon an entry, and the reason why is that we record these sessions, and typically that will make a better recording for us, because we would like to put our presentations up on our YouTube channel at the Arc of Mass. And so if you weren't able to view it today or you want to view it again, you're more than welcome. And also at the end of this session, you will be getting a PDF copy of the PowerPoint presentation. So at this point, Michael and Marianne, why don't you take it away?
Great. Can you hear me okay?
Yep.
Great.
So, welcome, everybody.
Yes, welcome. And also, in addition to myself from the ARC of Berkshire County, we also have Jennifer Sweet, who's our Director of Trust Services, who's here to help address any kind of questions.
Thank you, Jennifer, because Missy Francor was going to be here, but is out with the flu. So I appreciate you being here, Jennifer.
Thank you. Hello, everyone.
All right, so we want to kind of go over some of these basics because some of these things can be a little bit complicated. So we've tried to kind of break it down in terms that make sense, at least we hope. And then from there, leave some time for some questions. This way we can address any particular nuances that people may have. So we're going to just jump right in and talk a little bit about, where did this come from? So the ARC of the United States was pretty involved in the creation of pool trusts. It was actually guided by and created by the Omnibus Reconciliation Act of 1993, or as many folks refer to it as the OBRA Act, and really looking at how we were actually looking at ensuring that people's funds were protected and managed in a way to ensure that they could maximize their benefits and still be able to access supplemental funds so as to have a quality of life. Prior to the OBRA 93 transfers, were not tied to Medicaid eligibility guidelines. So a lot of this really had to do with Medicaid reform and ensuring that there was a vehicle to ensure that people with disabilities were able to have some supplemental assets with certain guidelines and certain rules so that they could access those funds and that they would not impact their Medicaid benefits, or here in Massachusetts, Mass Health benefits. So, over time, things have changed, and we'll go over more of the specifics throughout this webinar so that people can understand the nuances and some of the specific rules and guidelines, as well as we'll end the webinar just talking about this new thing that people may have some questions about, the ABLE Act and ABLE accounts, and how do they differ from pool trusts and supplemental needs trusts. So that's kind of the background. And I'm going to transition to Marianne as to why these are important.
Yes, welcome everybody again. So honored to be doing this webinar with Michael and with Carrie and you folks. And why is this important? The task of providing for long-term management of funds for the benefit of an individual with special needs can be challenging, as we have seen over the years. It can be of the highest importance for people with disabilities to maintain their public benefits, such as Social Security and Medicaid. It's often necessary to have SSI and Medicaid to qualify for other benefits, such as rehabilitation programs and services, adult family care, PCA services, subsidized housing, food stamps, etc. Both SSI and Medicaid have strict asset requirements. The recipient can have only $2,000 in assets. So when a person comes into new resources for a particular unforeseen reason, this can put their resources over the asset limit. Instead of spending money frivolously, which we used to have to do for many, many years prior to the trust being implemented, the Social Security Act allows for two preservation vehicles, the Special Need Trust and the Pool Trust. This presentation will highlight the benefits of the Pool Trust and trust management services offered by the ARC of Bristol County and Bristol County ARC, and Berkshire County ARC, sorry.
Thanks, Marianne. So how does a special needs pool trust differ? You may have heard of other kind of trusts. Well, this particular trust is required to actually have a nonprofit organization administer this type of trust. So you may have heard of D4A trust or all this kind of alphabet soup. This is specifically a D4C trust. And again, where other kind of trusts may have a private trustee, in this particular case, only a nonprofit organization can serve as a special needs pool trust administrator. And the reason for that is the idea of, and we'll get into it a little bit later, is that these particular trusts do have a remainder provision where there's a certain percentage that goes back into the charity or the nonprofit organization that is administered. And when they designed this, it was with the intent to help that nonprofit organization have capacity to continue this work. Again, for those to qualify, the individual must be disabled under the Social Security definition. And when people talk about pool, they hear the word pool. Does that mean everybody's money is just kind of thrown in one bank account? No, that's not how it works. When the reference to the word pool talks about pooled for investment purposes. So unlike many smaller accounts where a lot of financial advisors may not be interested, we are allowed to then pool the funds together so that we can then take full advantage of the investment option so that we can provide a better return for those invested assets, thereby being able to grow those assets so that they're there in perpetuity for many individuals to have access for those supplemental needs. There are two types of pool trusts. There is what we call a self-funded pool trust, and that's when the funds actually have actually gone to the individual. And a third party, which is perhaps a parent or a family member has funds on behalf of an individual that they want to then invest and provide those funds into the pool trust for administration and support. And there's some different nuances that we'll get into as we go forward.
This is me, Michael.
Yeah,
I Michael, I thought I had our slides there. I thought I had this backwards. As Michael was saying, the individual pool trust is funded by the disabled person's own funds, often from an inheritance, a personal injury settlement, or a retroactive Social Security payment. Allows individuals with disabilities to maintain resources greater than their asset limit, which we had mentioned before, without losing eligibility of public benefits. It is a Medicaid payback trust, and the assets are pooled among many beneficiaries. Lower fees as compared to a special needs trust administered by a private entity. And I just wanted to say that the ARC has been advocating and providing exemplary services and supports to individuals with disabilities and their families for many years. And we have, expert knowledge in the complexities of public benefits. We offer peace of mind to families, and families trust the ARC, to understand the needs of their family member with a disability.
And I think to that point, I constantly think of concerns around legacy. At the end of the day, leaving, working with the ARC and recognizing that we've been over 60 years in terms of making sure that we are committed to supporting families and individuals, not only today for the past 60 years, but hopefully way after I'm gone and many of the folks that are currently in our generation are gone. So trying to leave that piece where there's many families that will come and they're concerned around that legacy. Who's going to be responsible if I'm leaving this investment? What can I do to make sure that it's protected? And I think that's one of the pieces that the ARC's reputation stands high, is the fact that we've ensured that we've always worked with integrity in making sure that those funds are being managed properly and that they're the direct beneficiaries getting wraparound services from our expertise and a variety of different services so that we can ensure that those funds are there for perpetuity. The other piece I just want to touch upon is that what's this Medicaid Payback Trust? Some folks may not understand what that is. That basically means that upon someone's death, the first person we have to notify, after clearly we get notified from family members, is Mass Health. It's Medicaid. This particular pool trust is designed where the state and the federal government said, you can use these funds for supplemental needs while they're alive. But then when the person passes away, we need to be notified, because at that point, they have a 1-year window to submit any claims against any funds that are left in the person's account. Those funds at that point will be subject to any funds that Medicaid paid on their behalf since the inception of the trust. They then will put in a claim and tell us what was paid out on their behalf for Medicaid claims. Now, if that amount is smaller than what's in the trust, we would simply pay out what the Medicaid claim is, and then the balance we would distribute to the beneficiaries. If that amount is greater, then we would just pay out what is in the balance, and it will close out the mass health requirements. So again, a little different as I talk about some other kind of trusts later. This is a provision that was built into the federal government, where basically the feds and the state said, we have to have a payback component if there's funds available. Again, we talked a little bit about the fact that these are administered by a nonprofit organization. They're irrevocable, so that once you put the funds in and you establish, you cannot change your mind and then take them out. At that point, there would be fiscal consequences. So if in fact, for some reason, an individual or family wanted to close out a pool trust and the trust agreed, then those funds would all be subject to Medicaid penalties. And at that point, they would no longer be protected assets. This remainder assets that are retained by the nonprofit organization, again, I talked about this earlier, where the intent is that most of the pool trust organizations have a flat remainder fee. Many times it's a flat percentage. They vary across Massachusetts and across the country. I'm happy to say that the ARCs, both Berkshire County ARC and the ARC of Bristol County, are the lowest in the state. We pride ourselves on ensuring that we try to minimize the costs for the work that we do. At the end of the day, it's about making sure we provide adequate protections, but the remainder assets that we do have. So just to explain, so assuming someone has $10,000 and they pass away, the two ARCs and any other pool trust are able to then charge a percentage fee before the mass health remainder. Our fee is 5% in the first 2 years and 25% after. And I believe the ARC of Berkshire County ARC is also 5%, and is it 20% after?
After 2 years, yes.
So we're pretty consistent. I think another big component that we really work hard is, again, to make sure that people are maximizing their benefit levels. So we make sure that we don't issue any kind of cash to the individual. If we did, then that would count towards Social Security income, and it's in direct violation of the trust provisions. So we work really hard to ensure that those supplemental needs, which we'll explain in a bit, are maximized, and that those funds are really used for what we call the sole benefit rule. Has to always tie back to how is that person going to benefit from that expenditure. You know, in some examples, one time we had an example that there was a family member who wanted to put together a family reunion and wanted us to pay $25,000 for the family reunion cost. And we talked back and said, you know, we understand that you want this person to do this great thing and host this party, but it doesn't tie back to the sole benefit. We have to think about how this person certainly could have a share of that because they're going to benefit from it, but they shouldn't be responsible for a family reunion of 30 people and they're flipping the whole bill. So part of that is us making sure that we're always looking at that sole benefit rule and supporting the needs of the beneficiary. Mary Ann, do you want to cover this one or do you want me to take it? All right, we may have lost Mary Ann. She's having some technical issues in her office today. So in terms of the third-party pool trusts, again, it's a financial planning mechanism. How is it? Because the reality is that, you know, sometimes Social Security decides they made a mistake and they may send someone a check for $30,000. And they say, oh, and by the way, you have 30 days to spend that check. Well, for most people, that is a hardship. So the third-party pool trusts allow the individual to take those funds. It's not going to a lawyer and paying all these additional expenses. It's a flat fee to get enrolled. There's what's called a joinder agreement, which is a simplified legal tool, which is fill in the blank. And then from there, we fund the pool trust and we get it up and running. And then from there, those assets from the date that those funds are deposited are no longer counted towards any of Mass Health or Social Security components. The example I just gave was an individual. In this case, third party is really parent, grandparent. And here, one of the key components is that it's not a payback trust. So why that's important is I just talked a little bit about how Mass Health and Medicaid captures their portion at the end. In third-party pool trusts, there is no payback provision. So whatever's left will be disseminated to the beneficiaries. So why this is really important is that, you know, sometimes we find that family members want to leave a check for their loved ones. We don't encourage that. We encourage that if they want to create a third-party pool trust, that this is a financial mechanism where that they can invest. There's not the cost of setting up a full trust, but they have the full benefit of all those assets being in a protected way with the nonprofit trustee. In this case, the ARCs, we're managing it, so we're complying with all the guidelines. But at the end of the day that person passes, Mass Health is not notified because it's not subject to Mass Health, and whatever assets are in the trust are closed out, and then at that point sent to the beneficiaries. Again, same approach in terms of investment purposes. They are pooled for investment only. So everyone, again, I don't want people to think that when you hear the word pool, that suddenly everybody's money just kind of get mixed around. They are invested from that platform. So when we work with investors, we get better rates when we're able to then come with a much larger asset pool to then negotiate and have better tools and available for folks. Some of these other areas I've already covered. So the same rules apply. So in terms of, with the exception of really that Mass Health payback, everything else stands. With the third-party trust, there's also not a flat remainder percentage. That's negotiable with each pool trust agency. So you then would want to have a conversation about what their fees are. Whereas the other ones tend to be, we tend to be kind of similar across the state. Again, with the two ARCs being very close, you'd want to, this is an area that is not necessarily a requirement for third-party pool trusts. So the ARC of Bristol County Master Pool Trust. So we started our trust a little late. We started ours in 2013, and quite frankly, we looked at the model that the ARC of Berkshire County had and the work that Mary Ann and that team was doing. We very closely modeled ours after theirs. We looked at, in our area, down here in the southeast of Massachusetts, many folks were concerned about, having their funds being shifted to different parts of the state. And we identified down in this region that there was a need and an interest for us to establish this tool. So we worked hand in hand to kind of create and mirror some of the work that Berkshire County ARC had established, and trying to make sure that we had all the different compliances and some of the same, maximizing some of the same advocacy that we had done with some of our other services. The way we did it, similar to Berkshire County, we reached out to a local bank. Bristol County Savings Bank was a great partner. And since subsequently, as we've worked with them, they've developed a new arm called Bristol Wealth, and they serve as our investment managers, where they know investment. It's not our job to be the experts on investment. We bring in, they work with companies like Raymond James and a variety of other financial tools to ensure that the returns are consistent with market. Our investment policy tends to be more conservative and balanced. Ours falls within a 60% margin of investments and 40% margin of in terms of more conservative approaches. So we try to be mindful that we want to make sure that we want these funds to provide maximum returns, but at the same time, we're careful to ensure that we don't put ourselves in a high risk situation for folks. And we also adopt the same investment policy for all of our agency funds. Mary Ann, you back? All right, so let me pitch in and try to see how well I can describe. Very similar. Again, they've been doing it since 2002, and they have an outstanding reputation. I've gotten to know Mary Ann and many of the different folks that work out of the Berkshire County office, and they just do such a great job. They've always been a resource to us. We've been actually, over the past few years, been able to work together and be able to help support people. So in situations that are complex, we work together to kind of brainstorm, be creative, address any of those concerns. Similar to the example I gave of Bristol County Savings Bank, they work with Berkshire Bank and have also built a strong fiduciary responsibility and relationship to ensure that all accounts are managed properly, and that all of the quarterly tax information is consistent with all of the requirements and all the different regulatory bodies that we are accountable to. Similar to the pool trust, the Berkshire County ARC also has a family special needs trust. That's that third party trust I was talking about. Yeah, Bristol County also has one as well. And their current assets around 11 million that they're managing. Mary, are you back?
I just got back. I lost everybody. I'm so sorry. We're having terrible internet and phone.
So I was just finishing talking about Berkshire.
Thank you. I just got back when you ended my press. That's fine. Thank you. I'm so sorry.
Is there anything you want to talk about Berkshire County and just the trust services? I kind of just went over the highlights of the slide, but anything you want to say?
No, except that, we are, we've been, as you said in the slide, I don't want to repeat it for everyone, but, families often come to us and others, and because they trust our transparency in providing them the information and the expertise that we've had in, overseeing public benefits and ensuring public benefit entitlements. We work with attorneys across the state and families and individuals. So, you really, really covered everything that, I was going to. So thank you.
No problem. All right, so the pool trust process. Typically, a beneficiary will submit an application and an enrollment fee. So again, just be mindful of our enrollment fees are pretty consistent. They're a lot less expensive than actually establishing an entire trust. However, there is a legal review that we do have that's what that fee goes towards in addressing. That legal fee reviews the joinder agreement and that is the process that the individual must sign. That's that fill in the blank form I was talking about earlier. We then have the joinder signed by the organization and the check to fund the account. And then at that point, the account is established. The ARC's attorney will review to ensure that there's no concerns with Social Security or Medicaid, to ensure that so sometimes there may be a power of attorney that they need to do additional work, and there's a difference in fee, or if there's a particular court order or any nuances. What we want to make sure is that these trusts are not going to be contested. So part of that legal review is just to make sure that there's nothing that is sticking out from anyone that would raise any concerns. And then from there, assuming that all works, the account is open, and at that point, we would then meet with individuals to talk about how to disperse funds and go through that process. And speaking of disbursements, Mary Ann, do you want to chat a little bit about disbursements?
I've lost your screen, Michael. I'm sorry. Are we talking about disbursements and protections?
That is correct.
Yes. Disbursement request form must include required documentation, invoices, receipts, proof of payment. All must benefit the beneficiary. That's what is so important. We have a duty and responsibility to ensure any disbursements from the trust do not jeopardize, the trust members' Social Security benefits and comply with state and federal regulation. Trust disbursements are to enhance the quality of life of the member and are used to supplement Social Security benefits. And when making a disbursement, it's imperative that the trust manager, which is us, review the assets in the trust, current life situation of the beneficiary, such as health, current and future needs, and any unexpected needs. And it's a good practice that to have a member disbursement plan developed upon entry into the trust.
Great. So use of remainder funds and why the ARC. So again, as I mentioned earlier, federal and state laws allow the pool trust program to have an approved remainder funds policy, which the funds go directly to the organization. Again, for the ARC of Bristol County and Berkshire County, we use these funds to cover the costs associated with managing the trusts, all of the work that involves getting to know individuals and trying to understand what other particular concerns or challenges, or just understanding what other services folks get to ensure, like, so for example, if someone has a rep payee, we need to make sure that if there's any issues with their rep payee account, that we are working hand in hand so that we can fully maximize people's benefits. Same with, let's say there is a life insurance issue, or there's a burial plan. There's a whole bunch of pieces that we want to get to know, so that for futures planning, we are helping with that process and using this as another tool. Then lastly, is really support the advocacy to individuals with disabilities, and making sure that we continue the work that we've done for 60 plus years, and that we're looking not only at the folks that are benefiting from the trust, but also looking at policy levels and watching any potential concerns that may be coming down from either the federal, state, or local governments. Over the years, there's been many threats about making changes to federal and state policy, and we work really closely about ensuring that we have a high level of advocacy, that any new policies or any changes would not adversely impact people with disabilities. Mary Ann, do you want to just touch base on the remainder policy, or do you want me to cover it?
I'm losing, it's going in and out. So I'm afraid I'm going to lose people if I start it, Michael.
Okay. You know what? Actually, I think I covered pretty much all those pieces.
Yeah, I think you did too.
Yeah. So let me wrap up so that we then leave some time for questions. I'll talk about the ABLE account. So some of you may have heard about the ABLE account. The ABLE account is a tax advantage savings account for individuals with disabilities and their families. And it was actually the official title of the ABLE account is the Stephen Beck Achieving a Better Life Experience Act of 2014. Where this came from was a lot of advocacy from self-advocates, the United States, and a variety of other groups, where they felt that the concern that we had for folks with people with disabilities, they had no options to be able to actually manage funds. If they had excess funds, the only option was to go into the trust. And they felt that there were many individuals who wanted to manage excess funds, but they were being penalized. So what they decided to do was then go forward in thinking about a tool that would allow so many funds to be placed in an account that would not count towards their Social Security nor Medicaid asset levels. The need for this, again, continued to be many individuals and self-advocates expressing that they wanted to manage their funds, but they had to deal with other people, and they weren't able to, even with refugees, they were being forced to spend unnecessary funds, and they really wanted a tool to allow for more empowerment. Who's eligible for an ABLE account? So we initially wanted everyone with a disability to be part of this, but the federal government, in terms of the negotiation of this act, determined that anyone with the onset of a disability before turning 26 of age will be eligible. So the diagnosis of the disability has to be diagnosed before the age of 26. That's important because if we're talking about someone who, for example, suffered an acquired brain injury at the age of 30, they would not be eligible for the ABLE account in its current form. We're advocating to raise the age. This year, I believe it's to 46, but that's still in play with the federal government. They're going back and forth. Why that's a concern is because the actuaries who looked at calculating how much money this would cost determined that it was too much money. So we continue to advocate and continue to kind of find ways to expand that definition. As far as the limits of the funds for ABLE accounts, so when it was initially started in 2014, limit, so let me explain just a little bit. So this was tied to, for those of you who are familiar with the IRS 529 college plans, this was a subsection of that plan. So what they did is when they created the ABLE account, they went to the IRS, they found kind of a home for this, and they thought that the 529 program made most sense. And basically it allows folks to basically put away funds for college. So in their mind, they felt that this was allowing individuals with disabilities to put away funds for what they call disability-related expenses. So they added a limit similar to the same limit for the college savings, and what our limit was initially was $14,000, and last year they raised it to $15,000. However, the maximum amount that you can have in this account that is allowed for both Social Security and Medicaid eligibility is $100,000. So each year, the max you can put is $15,000. And then with a collective maximum of $100,000, that would be sheltered assets. As far as which expenses are allowed by ABLE accounts, the definition was left very vague by design. It's called a qualified disability expense. And in the regulation, it talks about these things may include education, housing, transportation, employment, training and support, assistive technology, personal support services, healthcare expenses, financial management. In essence, a key difference from some of the other trusts is housing was a big component, because housing in those other trusts, we have to be careful because housing and food are considered basic needs. And if folks are in SSI, Mass Health and SSI acknowledge that that income they received is already being provided by that, and that would be a countable asset if we release funds for those particular areas. So this was definitely a win with the ABLE accounts to allow housing. The question is, the onus of the disability qualified expense falls on the person with the disability. And the IRS at this point has the jurisdiction to then audit and hold people accountable. This is still too new to understand how they will do that. Right now in Massachusetts, the group that does it is MIFA, the Massachusetts Educational Finance Authority, and they have engaged with Fidelity for purposes of investment. In this model, people can only have one account, but you do have options. You don't need to, even though you live in Massachusetts, you don't need to pick the Massachusetts account. You can go to any state that you want and open up an account, but you can only have one. And again, as I mentioned, there's the yearly limit of a $15,000 contribution and the max of a $100,000 contribution. How are these funds different from trusts? I think the main thing is that these funds, so Fidelity is an investment manager. They're really good at making sure that you can invest funds. They will ask people about how they want their funds invested. What they don't do is they don't provide guidance as to what you can use the funds for. They don't provide guidance on how is this a disability related expense. They don't provide any kind of what we call counseling. So many other federal programs have cash and counseling components, and they typically go hand in hand. In this particular program, there is no counseling other than they'll guide you about investment purposes. They'll guide you in terms of how to set up an account and then how to access the funds. But that's as far as they go. So if there's a person that has issues with managing money, I'd be concerned about recommending this type of account because it will give them greater control. And again, it comes from a place of empowerment, which is a good place, except we know that there are some individuals that need additional help. And having them put the funds in these accounts, if they don't understand, then potentially they could have some exposure and some risk. But if they can understand and they have the full ability to be able to maximize their funds, then I think this would be a good tool. But I know lots of folks have asked me about the ABLE account, so I wanted to add this slide so that we could express some comparison and kind of just give you some background on it. And that is our presentation.
All right. Well, thank you, Michael and Marianne. This is Carrie. We do have a few questions for you. So Lisa is wondering, do you have approximate costs for pooled trusts?
So if you go to our websites, all the fees are listed. So I know on our fee, what's our fee, Jen? Do you want to walk through that?
Right. The intake fee for anyone without a guardian or a power of attorney is $475. And anyone who does have that kind of representation is $575.
Yes, and for our basic enrollment fees, one-time non-refundable $500 to offset our costs, and if there are exceptional enrollments involving a conservator or a power of attorney, it's $600 for the intake enrollment fee.
Okay, thank you. And Lucy is wondering, what percentage gains have the trusts made in the past year? And then the second part of the question is, can you recommend estate planning attorneys and or financial planners who are familiar with your trust?
So I just looked at our investment report, and again, this is, I would say this is a strange year, being that the market has done really well, but on average, our return has been 16% this past year. And as far as we do recommend, depending on where people live, we certainly have relationships. We don't necessarily endorse anyone per se. We would share you a list of attorneys that we've worked with that we've had good experiences with.
And I would echo that, Michael.
Okay, all righty, thank you. And Beth is wondering, are there any other affiliates, ARC affiliates in or closer to Boston who also offer pool trusts?
Well, Michael, you're probably closer to that area, but we work with members across the state. So a person doesn't have to necessarily live in your geographical area to be able to serve them. Am I wrong, Michael?
No, correct. You can live in any town. You live in Massachusetts, you can.
We have clients as north as Salem and as south as Martha's Vineyard.
Yeah, and we have several clients too out in the middle of the state as well as Western Mass.
To that point, this type of service typically isn't one that, we try obviously to at least meet face to face once a year with folks, but this is the type of service that when you need something, you call, you send in a
Right.
request. So as far as that, having that face to face component, it is a little different. I understand the locality piece. That's part of why we created a pool trust down here, because in many people's mind, they want to have closer access to that. But we are the only two ARCs in the state that do provide pool trust services.
Okay, thank you. Any other questions? You can chat them in with the chat box.
Yes, and they do, everyone has our email address. If you want more specific fees to talk about other circumstances regarding that, we can talk about that.
So hopefully we just did a really detailed job.
I can't believe my internet went down.
But again, I know that we just threw a lot of different information, and again, we live this every day. So if there's questions or concerns, I absolutely echo Marianne's sentiments that we're happy to respond to any email questions. Both of us have our information on the websites, so that if there's additional information you want to see, including the fee schedules, including the joinder agreement, what it looks like. And again, if you have questions, we're happy to address them.
And I guess I just want to echo one other thing, because I think that's when my computer went down the first time, that it's never too early to start looking at futures planning. And that's the mechanism for the third-party trust, the Family Special Needs Pool Trust, is a really wonderful mechanism to look at, the future. And it's never too early to start talking about that.
Okay. Well, Evelyn just wanted to thank you for all the details. She says this is a lot to think about. Pam has a question. Would pool trust be in addition to a special needs trust, or does it replace a special needs trust?
So
well, go ahead, Mike. Go ahead.
It depends.